Thank you, Kira, and thank you everyone so much for joining us today for our webinar on optimizing customer relations during pandemic, a legal perspective. For those of you who are new to Workbench, a very warm welcome. We are an enterprise-focused VC fund based here in New York, all enterprise all the time, and we invest in enterprise software startups who sell into the Fortune 500 across the country at the C2 stage. And I know for so many startups and founders that we work with, this legal side of the house can feel especially painful and oftentimes a total headache to deal with. I know it is for me personally. And so I'm really pleased to be joined by a longtime friend of Workbench, Dror Futter, partner at Rimon Law, who spoke at one of our first ever Workbench workshops back in 2016. And one of the things we most respect about Dror is his empathy for startups and his real talk. We know a lot of lawyers will just tell small startups that in a lot of situations, they'll give advice that's more fitting for a large company, or just tell startups, this is what you have to deal with. And what Dror does so well is say, okay, this is your situation as a smaller emerging vendor, but these are also the creative, thoughtful ways that you can protect yourself. And nowhere is this more clear than in the playbook that Dror authored for us. Kira, if you can actually drop that playbook link into the chat, based on what I know so many enterprise software startups were facing at the height of the pandemic. So dealing with customers who are facing financial hardship, customers who are asking for refunds, payment deferrals. And I know for so many of our early stage startups and for many of you on the call, we, of course, felt deep empathy for all of our customers and wanted to, of course, see what we could do. But at the same time, our startups have to manage their own businesses too. So we're going to have Dror give us a talk track over the 3 key areas in the playbook. And then what we really want to do is just jump in and take all of your questions. Sound good? Okay, awesome. So first things first, Dror, what did you do during the pandemic to stay sane?
So I think the absolute key is I'm a runner. I've been a runner for the last 20 years, when marathons return to our area, I will be in prime shape for them.
Oh, awesome! Kira as well was actually meant to do a half during the time, so we'll be there cheering you on. All right, so I guess just to set context for our conversation, right? I mean, we're now coming up on almost 6 months since the start of the pandemic in March. Dror, are you still seeing customers asking for relief at this time? Have you found that customers' ability to pay has improved since March?
So again, I think in terms of my clients, in terms of the legal services, knock wood, things have kind of been relatively business as usual. In terms of the feedback that I'm seeing from my clients, it's better than I would have thought. And I think, we've had, we kind of have every 6 or so weeks kind of an internal firm conference call of the venture attorneys. So we've had a couple of those since COVID started. And I think the 2 bottom lines is the picture's mixed. You're definitely seeing customers having to cancel projects. Much more frequent is just customers deferring projects. Issues with payments, but on the whole, a lot less. If we were having this conversation in March, and I actually did a kind of a crisis, breaking crisis type webinar in very late March of 10 things that startups should be doing now. Those felt wholly justified and reflected what everyone was seeing in the market. But a lot of the worst case scenarios haven't materialized.
Great, that's the silver lining. I think, Kira, if you want to hop over to the next slide, we can break into the 3 areas that we covered during in this playbook. And I know, your high-level takeaway, Dror, actually is around this idea of being proactive. If you want to share a little bit about that.
So if you think about it, right, it's just like the baseball season. This is going to be the year with the asterisk. And so if you're an early stage startup, you've been working really hard to keep the growth curve going sharply up and to the right. And maybe you don't get a do-over, but this is the year where if there's some discontinuity, everyone's going to understand it, and you're not likely to be scrutinized for it. which actually gives you a little bit of flexibility that you might not have when your numbers really are counted. And so one of the things that I've tried to suggest in this presentation is a bit of customer triage. My working assumption is that for most early stage startups, by and large, they've kind of frozen hiring. They maybe have done layoffs. So it's a situation where you're trying to do the same or more with less, which suggests that you should also be prioritizing your customers. And I think you have to think about your customers in somewhat different dimensions than you did traditionally.
Yeah, and I think the word proactive is such an interesting one, right? Because, for most of our startups, they are earlier stage enterprise startups selling to much larger customers, right? And oftentimes when you are dealing with these legal contracts, you often go with whatever the customer, they're setting kind of the framework, if you will, or setting the stage. So I'm curious how you've seen startups, be successful while in being proactive.
So the question really is, let me put it this way. I was a general counsel before coming back to law firm practice of a video conferencing startup for 3 years. And when you think about a sales pipeline, it's kind of very contract focused in terms of, I think I can do a contract for this amount of sales, and it's got a probability of 90%, and I've got this further part of the pipeline that's out that has some lower probabilities attached to it. And you tend to very immediately go after the high probability next contract. What I found both from my prior experience and then clients that I have now working through in the context of a law firm, these tend to be aggregated numbers. And so not a lot of attention is paid to how profitable is a given customer. So you focus on the revenue that customer is generating, because again, that you have that obsessive focus on growing revenue. But at the end of the day, the question is, how profitable is that customer? And everybody has, not all sales are created equal, even if it's a pure software play, right, where the incremental costs of the underlying product are low. You still have those customers, and everybody has them, that just require a lot more hand-holding than all the other customers. And they're just more resource-intensive customers. And so this is kind of an opportunity to focus your attention on those contracts which are the least demanding and the most profitable, which is kind of a triage that we don't normally do in most times, but I think is more essential. And I think that what I'm seeing with my clients is, everybody is trying to develop a sense of who are my, it's kind of the mirror to what venture firms are doing these days, which is figuring out, who are the horses in their portfolio that they really think they can ride to exits, and focusing their capital on them. So on the venture side is figuring out kind of which are the customers that are really worth focusing resources on. And I actually, in the slide after this, if you want to just flip to it, kind of give 3 dimensions that you can use to evaluate.
3 Ps, yeah. And that's what you said, right? Customers, not all customers are created equal. And I'm going to actually have Kira pull up the playbook so we can just reference the
Okay, I thought it was there. I can just walk people through it.
But I guess for I'm curious how you think about, customers who are Fortune 500s, right? And customers who are startups, right? Because even with our startups, many of them sell into other startups. There's obviously pros and cons of both. If you sell into a startup, usually faster sales cycle, but smaller ticket sizes, higher risk of churn. Customers who are Fortune 500s, right? Much bigger ticket ACVs, but long sales cycles, right? Tend to be a little bit stickier and less risk of churn. How have you seen that play out during COVID?
So I think that in general, the pace of new transactions has just slowed down. And so I think a lot of new deals are just not happening. And that's been a consistent theme. Now, there are exceptions to that. I have some clients in the life sciences and pharmaceutical space where it's kind of been very much business as usual. But on the IT side, you just kind of hear a lot of, we send the first draft, it's been sitting there forever. So the slow big companies, by and large, are going to be slower, but I think you're going to find your startup customers unusually slow because they're going through their triage drill, and I'm certainly seeing, in those ventures where a lot of the sales are startup to another startup, that speed advantage is not quite as sharp as it used to be. And then the flip side is, one of the criteria that I don't think gets focused on a lot in the good times, particularly for a software company where you are you're not carrying inventory or ordering parts, is the ability to pay. And that's, you might, a lot, even with, kind of rudimentary things like credit checks are not something people routinely do. But you can only service X number of customers, even if you're selling a software product. And that becomes a more important criteria.
Yeah, absolutely. And if we go on to contract evaluation on the next slide, I think this is really interesting in terms of all the different critical terms that startups should be paying attention to. Which one do you think startups do not, think about enough, especially early stage startups?
So I'd kind of answer that in two parts. I mean, I think in general, correctly, startups realize that they're not going to be able to dictate payment terms to their larger customers. Cash is king right now, and so payment terms become very important. And it's one of those things where if you're dealing with a large corporate, you might, and it's a kind of a true partnering relationship, it's a point I would raise with them, because at the end of the day, interest rates are ridiculously low. So if you're dealing with a company that's doing well, it's a bit of a dicey drill, because take one step back. When you're dealing with a large corporate, and this was something I said in the first panel I ever did for Workbench, you really have a three-headed monster you're dealing with. You're dealing with the business person who hopefully really likes your product. You're dealing with legal, who's basically in the business of risk avoidance. And then dealing with sourcing, and their primary metrics are price terms and price savings, right? So when you're approaching existing customers and trying to adjust terms, if you have the opportunity to kind of help you ride out the storm, right? So payment terms is one of those things where there are corporate policies that require, and they've been pushing those out more and more, so you get net 60. I've seen agreements that by the time you do the math on the clause, go all the way out to like net 90. That's kind of death for a startup in this environment. And to the extent you can talk to ventures, to customers about improving payment terms, that's something that's very helpful in this environment. And the reality is, it might even be something that, again, because you're not quite as focused on revenue as we might have been 6 months ago, you might even horse trade pricing for a while and offer a discount to get the money in the door. Early payment discount. That's a really critical term. Volume. If you can get customers to commit to minimum volumes, it'll help you triage efforts. You can kind of hopefully promise them some improvements in services, some other things to wrap around it. But to create the win-wins here, you got to kind of view it as a balloon. If you're going to push here, it's got to come out somewhere, and you've got to figure out kind of what your easy gives are before you enter those kinds of negotiations.
Yeah, and I love the three-headed monster, analogy, and we can't see everyone on the call, but I'm sure everyone is nodding along. I'm curious, when you think about it from sourcing, which of these terms is the least painful for them, right? Because the sourcing team has terms that is easy for them to give, right? Versus other ones.
So it's kind of ironic because, again, everybody kind of has their tunnel vision in large corporates. So the reality is, a lot of the performance issues that'll cause the business person to kind of jump off the bridge in frustration is not really a sourcing concern. Yeah, eventually, if you're really poorly performing, sourcing will be the one to convey those concerns. But if it's kind of an adjustment battle with the person for sourcing, the performance-related aspects are going to be secondary to them. If your lead in negotiations is the business person, then that's going to be primary, and pricing might take a little bit more of a back seat. So it kind of depends what your dynamic is of how you're talking to the organization. In some cases, once general product is identified, the business person takes a back seat and it's in sourcing land until you sign a contract. So it really depends kind of what levers you have to pull.
Yeah.
And the other piece of the puzzle is, in addition to kind of being a situation where maybe there's less pressure, and again, I want to be clear, not no pressure, but less pressure on revenue, it's also a situation where kind of everybody is doing bad, and it's a question of extent. So having a conversation with a large supplier, and saying, I need some help here, I need to kind of revise the way we're partnering, is not kind of as risky a move as doing it in the good, in the good times. And one of the things that I try to stress in the playbook is to really be proactive about it, because the more lead time, if you kind of wait for it to be in crisis mode, there's a lot less you can do. And the earlier you can start these conversations, before you've disappointed the customer, before your financial pressure is more acute, the more tools each of you brings to the negotiating table in terms of revising the arrangement.
That's right. And we got a great comment from one of our attendees who used to work in sourcing. Each of these terms are relevant to the deal based on the internal key stakeholders' requirements. Some teams in an organization care about some of these terms while others have different positions. So it may really change depending on the internal business line, which I think echoes what you're saying. I think, for us, where we see some of the tension is that our startups, our founders usually have an ear to the business champion, right? There's communication there. There's someone there really fighting for you. It's very hard to get an ear to the legal team and the sourcing team, because exactly to your point, it gets thrown to a land, and you may never get a chance to do a conversation where you can say, hey, look, out of these 6, which is the least, which is the easiest to swallow, right? And so I think that's where a lot of our startups struggle, is because there is very little opportunity to sometimes talk directly to the legal or sourcing team.
Yeah. I would kind of break it into 2 parts, new contracts and renegotiations, because when you're doing a renegotiation, it really pays to think back to what the dynamic was from the customer team to get you to the agreement. Kind of figure out who was the most sympathetic to you. In some cases, who was the biggest roadblock, and start that conversation early before you have a specific ask. Because at the end of the day, the worst thing from their side of the table is a negative surprise, because it's usually going to come too late for them being able to do meaningful risk mitigation. And so in addition to kind of increasing your legal exposure, right, your customer team now looks bad to the teams they support internally. And that's the worst case scenario, when they're now going back and saying, we can't finish this project on time because the supplier, this startup we took a chance on, isn't able to perform. So the earlier you can have the conversation, the better you can position transitions, mitigation steps, so that the damage is minimized or maybe even averted.
Yeah, and when we say early, we really mean early, right? Because sometimes in these very large corporates, these conversations can take months on months, even more than you already think. So, build in that time, right?
Yeah, the aircraft carrier analogy is very fitting.
Okay. Cool.
You can't turn it suddenly.
Yeah. Well, let's then shift to contract renegotiation and renewal. I know you just touched on that. And I know this is a huge one. I know a startup that unfortunately lost 1 to 2 customers during the peak of COVID, because they did try to negotiate some things during a renewal that ultimately rocked the boat, versus if they had just ultimately gone with the renewal, right, they would have retained the customer. So I thought that was a really important call out. And I appreciate the gives you talk about here. Could you kind of walk through some of the high level ones and which ones you see are being used really successfully?
Right. So, this is really focusing. Let's break this down into 2 parts if you're dealing with another startup or if you're dealing with a large corporation. Mm-hmm. So if you're dealing with a startup, obviously you're coming to the table with more leverage. And again, payment terms and doing homework on the startup to figure out what their status is critical to this. The one advantage that startups bring to this drill is you understand the funding cycle, so you have a better ability intuitively to figure out, if you see a venture that did their last raise 2 years ago, you intuitively know that's a venture that's at risk in most situations, and you just in general, startup to startup, have a better sense of who's struggling. So if your customer is a startup, you want to bring in the payment terms. You may want to go on a pure cash basis. So for example, if you have a SaaS model and historically you've been billing, at the end of the month, consider billing at the beginning of the month. In some situations, you might insist on cash or a letter of credit. Now, a letter of credit you would rarely see in a pure software business, but if there's hardware involved, so you really have kind of out-of-pocket cost of components, that can be very helpful. If the customer's orders have dropped a lot, you may be looking at renegotiating pricing or getting them to commit to a minimum, because again, at a certain point, the resources you're throwing to support them may not justify the cost of having them as a client, even if top line they're delivering revenue. And then if you have vulnerabilities that impact your ability to deliver, right, the extent you can put them on the table and address them. Most importantly, on kind of just a business person to business person level in terms of flagging them and trying to brainstorm with the customers to how you'll address them. Even better if you can address it in the contract. But those interruptions, if you're feeling them, if you have dependencies that prevent you from delivering, those are things you want to raise and address. In terms of flexible termination, I've gotten several questions from clients like, so-and-so is X number of months behind on payment. Can I shut them off? And to give you the very lawyerly answer, but it has the added advantage of being true, it depends, because situations like termination are very contract driven in terms of the exact wording of the contract. At a certain point though, if your cost of performance is high and you really have doubts about the customer's ability to perform, that's when I would have a call with a lawyer to review the contract and figure out where you stand vis-a-vis termination. There's actually a little used procedure where you can actually send a letter to a customer, it's called a demand of further assurances. You can actually ask them, are you going to be able to perform your end of the bargain? And if they fail to confirm that to you, you can terminate immediately. And you can actually wait and stop performance while you're waiting for that letter to come back. That's kind of an extreme remedy, and it's certainly one that's kind of relationship killing. So I wouldn't pull that, pull that randomly.
Yeah.
And then there are a slew of articles that were written about force majeure clauses. A spoiler alert, legal briefing coming up. Force majeure is a French term that roughly translates to acts of God. It basically means unanticipated acts that impact performance. Now, in US law, judges don't like to rewrite contracts that parties wrote. So they will only, unless there's putting aside a contract force majeure clause, they won't declare force majeure in the abstract unless performance has become impossible. And that is not the same thing as saying ridiculously expensive. So if there's some way for you to perform at almost any cost, a court will require you to do it. Typical force majeure clause that nobody reads. In 30 years of practice, I've had no negotiations around until the last few months, right? It actually says that if there's one of these acts of God, the party that's impacted can stop performing. But the courts read those clauses really, really literally. And so now is a good time to look at those clauses, dust them off, and figure out, does it cover the problems that I'm facing? Or on the other side, is it covering the problems my customer is facing, and will they be able to use the force majeure clause against me?
Right. Yeah, I feel like COVID should fall definitely under an act of God.
You know what, though? I would say, I can't put percentages on it, but if most companies pulled out their forms, it would be a tough argument on a decent percentage of it.
For the startup, or you mean for the customer?
Either way, in other words, the force majeure clause usually is bilateral, but the trigger event of what is a force majeure and the way it's defined in a very sizable percentage of agreements won't cover a pandemic. I literally now, one of the first things I do when I pick up a contract that's sent to me for editing, I add the word pandemic.
Now we know. Now we
Yeah.
know after 2020. They'll always be added in. Okay, awesome. Well, thank you so much, Dror, for that really quick and very really helpful look and overview into this playbook. Let's open up to questions. I know we have folks on the call who's maybe listening to some of this is triggering. Any questions from our attendees? I'd be curious if folks, experienced any of this or thought through any of these terms. Does this at all echo some of what you all have been experiencing these past 6 months? Oh, here's a great one. Thank you, Priam. If there's no termination for convenience and people want to terminate early, do you recommend a tiered penalty?
Well,
and maybe if you can kind of step back and give the rest of the attendees a little bit of context around that question.
Right. So typically in a termination clause, you'll have two kinds of termination. You have actually more than that, but broad strokes, you have kind of termination for convenience, which is anytime I want to break the relationship, I can, and it usually has a notice period. Depending on the kind of contract, it could be anywhere from 30 days to 6 months. And then there's termination for cause, which will get triggered by things like a breach of the term of the agreements, one of the parties is going bankrupt, et cetera. But it's not uncommon that the contract doesn't have a termination for convenience, and then in most cases, it only terminates at the end of the full term of the agreement. So if a company wants to get out of that, right, so there are a number of things that kick in at that point, because let's say I'm the supplier and Jess is the customer. Jess sends me notice and says, I understand I have 6 months left in my term, but I need to break the contract now. So what happens here is, first of all, I actually, as the supplier in that story, have a duty to minimize Jess's damages. So that if there's some way I can sell something to somebody else, recover something, et cetera. So it is kind of a two-way negotiation, but at the end of the day, other than damages that caused by the termination that I can avoid, Jess is on the hook. So, there is incentive because Jess is probably terminating because she has some problems paying. So I probably have some incentive from a practical perspective that I want to get some money in the door rather than have the risk that Jess is going to go out of business. So this is kind of a situation where you play a bit of let's make a deal and kind of bring in what you can and let Jess off the hook. The other possibility, quite frankly, is if you have a sense that Jess's problems are temporary, you may want to be a lot more generous and keep Jess as somebody who thinks highly of you. And one of the points I make towards the end of the playbook, which is really critical, there is going to be a tomorrow to this. I can't tell you when it's going to start. I wish I could, but reputations are really hard things to regain. And so being as empathetic as your resources will allow is really critical, because that's the stuff that's going to stand out. The players who kind of go the extra mile when they can, I mean, people have tough choices to make and you have to make them. But the way you do it and the flexibility you show is going to be really important. Now, there's one part of the question I didn't answer. Maybe you can post in the chat. What do you mean by tiered, I think it was tiered discounts?
I think it's tiered penalty.
Yeah, tiered penalty. I mean, you're gonna, again, if you can type in some clarification, that would be great. If I had to kind of guess, you would given the amount of contract that's left, you would kind of scale what the penalty is, and that's what the law would do if you had to take it in front of somebody in a black robe.
Okay, great. Another question here. So general thoughts on red lines during the pre-sale process, right? So big company legal always wants to red line startup contracts. Startups feel generally powerless. Any high-level thoughts and strategies here?
Oh wow! I wish I almost feel like you planted like I planted this question. So I actually have so Sherman, God bless. I actually have an article, and feel free to email me. The good news is when your name is Dror Futter, there's the only one of us. But I actually wrote an article. When I advise startups, I actually suggest to them that they have 3 contracts, as 3 form contracts, because there are 3 kind of customers. There are those that will sign anything you put in front of them, and you just create the most favorable agreement you want, send it out to them, they're going to sign it anyway. On the other side of the equation, well, in the middle, there are those that will use your form, but they'll mark it up heavily. And for those people, I try to create a form that's very fair and goes down the middle, because I don't want to spend a lot of time negotiating. For startups, timing is critical. And while it might make the lawyer in me feel good, if I delay the contract signing because I start my agreement out here and they come back with this and we start marching towards the middle, I'm not doing the client a service. So I want an agreement that's pretty close, a little favorable to me, but pretty close to the center, with the expectation that I'm going to minimize negotiations. Now, Sherman, for the question you asked, so when I was the general counsel for the video conferencing company, we had a lot of clients in telemedicine and finance, and they would send us routinely their user-friendly 70-page forms. And the one thing I knew was I was not going to get any of that changed. So what I did was I identified a handful of clauses. In the case of my old company, it was 6 clauses, and I nicknamed it the 6-pack. And we had a sheet that had those 6 clauses on it. And when somebody said, we have to use our form, we sent them the 6-pack. And that introduced our unique concerns to the discussion. Now, I wouldn't say that large companies routinely sign the 6-pack unmodified, but at the end of the day, it got us into a discussion about things that were important to us on our paper. Because at the end of the day, when you're dealing with a big company, where does an 800-pound gorilla get to sit? Anywhere they want to. And you're just not going to move them off their paper. So this notion of creating a rider is really helpful in getting the important things to you added to a pre-existing, very onerous document. And as I said, Sherman, if you email me, I'd be happy to send you the article.
Yeah, I think I'm trying to pull it up, Dror, because I'd love to share it with folks right now. One of the follow-up questions were, could you just share the 6 main provisions at a very high level?
So the 6 main provisions, those were very specific to my company. It wasn't general legal things. Like, I'm not going to tell GE or IBM how to revise their limitation of liability language, right? Maybe the CEO of IBM has the ability to change their forms, if asked correctly. So you're not going to change their forms. There were things, in the case of the video conferencing company, some of the things were relating to some quirks in our IP situation where we had certain concerns we had to address. And the goal of the 6-pack was addressing those concerns that were unique to our business model. They weren't necessarily going after things that were very negative against us, because in most cases, when you're dealing with large corporates, you're not going to get them changed.
Great. I think I found it, Dror. Deep from the archives. Is this the one from a?
No, that was the first one I did for you. It's actually a flavor of this.
Oh.
It is actually on Medium, but it's not that one. Are there other questions?
Here's another great one. All right. So how often do you see late payment as a viable reason to terminate the agreement immediately? How far can you go to secure a period for late payment versus the ability to turn off? Or is there a softer approach, right? The demand letter is a harder standard. Is there anything in between?
So a lot of it really depends on how you evaluate the customer, right? If this is somebody you want an ongoing relationship with, particularly if it's a software-based business where you don't have a lot of hard cost that's going into service, you should try to be as flexible as you can within reason. You really, in terms of turning somebody off, that should be the end of a process that has a lot of conversation to it, right? That should be something that should never surprise the customer. They should have heard 50 different ways. You should try to escalate within the organization, make sure the right people are hearing about it. That's kind of the nuclear option and the option of last resort. The demand letter depends a little bit on the nature of the back and forth. So, for example, I have a client that basically their supplier was their customer was acquired by another company, and that new company basically stopped paying. And we sent multiple invoices, multiple calls, right? There were two alternatives: go in front of somebody in a black robe, or have me send a demand letter. And so, and again, even as a lawyer, I don't want to permanently poison things, but I basically send a letter saying, listen, the agreement says X, Y, and Z. There is no basis to dispute your obligation. You're now X amount late, and we expect immediate payment, or we'll pursue other remedies. And it got the check, very quickly. So there is a role for demand letters. It just has to be towards the end of a process and not an opening move. It really should be when you have a sense that you're being stonewalled. I think there's another, is there another one?
I think that was the most recent one. Give another. Here's a follow-up one, which is, I feel like, the age-old question for that we are always thinking about. What are some tactics you use to convince a customer to use your paper?
I don't. I mean, listen. If it's Joe's Tech and Grill, right? Then you might use the traditional things. Well, it's going to extend the deal. I mean, the techniques. That the large corporates use on you when they want you to use their paper. So, if it's Joe's Technology and Grill, you can kind of
think like IBM, and then yeah.
Right. But the Fortune 500s of the world, they're kind of Baskin Robbins with one flavor. So you can have any flavor you want as long as it's their form. And it's just not, my conclusion after hitting my head against the wall, particularly when I was with the video conferencing company, was it's just not worth fighting City Hall. Your goal is, eliminate the absolute most outrageous things in their form and add a rider with things that are specific to you. And when I say the most outrageous things, again, it's going to be a one-sided agreement. Sometimes you have kind of outliers even by large corporate behavior. Those are the ones you want to, fight. I'm dealing with a contract now where there's no minimum requirements, and the other side wants exclusivity in a certain market. So it's like, let me see if I've got this straight. You're not guaranteeing me $1 worth of revenue, but you want me to lock myself out of the market, right? So that you can even fight, a large corporate on. But things like limitation of liability, those kinds of provisions, which ultimately become a battle in a large number of large corporate negotiations. Again, you're going to have to go like 18 levels up the corporation to get somebody to sign off a change to that. It's not happening.
Yeah, but you've seen a little bit more success with startups selling to startups, or selling
startup to startup. There's as I said, if it's a fellow startup, right? And they use lines on you like, well, it's our corporate policy. It's like, really? You've been in business 2 years. I'm not really going to be swayed by your corporate policy.
Awesome. Well, great. I want to thank everyone for your great questions, and really thank you to Dror. It's always such a blast because I think you really do have this empathy that we really appreciate, right? Empathy for the startups, for the corporates, and for all the lawyers in between dealing with the fun part of contracts. So huge thanks. Again, if you want to check out any of our other playbooks, Dror actually wrote a more recent one for us, which is from the corporate lens. So if you're a Fortune 500 and you're looking to buy from a startup, what are some things you should be aware of? It's another really great piece on our blog. And of course, we send our Enterprise Weekly newsletter every Friday to 18,000 people. Would love to see you on it. And Dror, look forward to cheering you on at your marathon, hopefully sometime soon.
Yeah, no, it's we're still keeping our fingers crossed on spring 21.
Awesome, awesome. Well, thank you so much, everyone, again, and we look forward to seeing you soon.
Thanks, everyone.
Thanks. Bye-bye.